Somebody in the comments asked, why do you have to go through a solicitor to instruct a barrister? Well, actually, in some circumstances, you don't. So I thought I could explain how that comes about and what are the pros and cons of doing that. But first, let's just start with the traditional old-fashioned arrangement with solicitors. You have a legal problem. It could be what we call contentious or non-contentious. Contentious is anything that might end up in litigation, although rather weirdly, employment disputes are considered to be non-contentious. But if you've ever been in the employment tribunal, they certainly can seem to be. And non-contentious might be, buying a house, entering a business deal, just, a planning application, anything like that. So you approach the solicitor, and most of the time the solicitor's going to deal with everything. So where do barristers come in? Well, traditionally, barristers' specialities are meant to be specialist advice and advocacy. So say, for instance, you approach with an issue about you want to do something and you're not sure about the legalities of that or the practicalities. And you go to your solicitor and they say, well, this is a bit specialist area. I mean, there are specialist solicitors in just about every area. So you could probably find one who could just, tell you there and then. But sometimes, say you go to your, usual solicitor or a high street solicitor or a family friend. If they don't know, they will instruct counsel to write what we call an advice or an opinion. Usually we call them opinions if it's civil and advices if it's criminal, but there's no sort of hard and fast rule there. And that can be on anything, sort of like, yes, this is your legal position currently in relation to some land or something, or a will. These are some strategies you could adopt. You're about to enter a business deal. Here are some things you might need to watch out for. Here are some sort of areas that you need to consider. All that sort of thing. Or it could be, I'm thinking of engaging in litigation with somebody, or somebody's suing me. Could you write an advice on the merits of the case, either the case that I want to bring or the case against me? And sticking with litigation, let's imagine then you find yourselves embroiled in a court case, either as claimant or defendant. The solicitor may then instruct counsel, instruct a barrister. And we have our respective roles there. Now, people sometimes use the GP versus consultant analogy. I'm not sure that really works, actually. What I liked was, imagine a court case is a huge container ship. The solicitor is the ship's captain. They make sure that everything's on board, it's all secure, they've got all the paperwork in order, and they sail that ship halfway around the world. But then, when they get to the end, the tricky bit, they get the harbour pilot. And the harbour pilot comes in and they just do the last sort of, little bit into harbour because they're very familiar with the harbour. And that's their sort of, that's their usual domain. A ship's captain might go into dozens or hundreds of harbours all the time. But, this one person knows everything about this harbour. That's pretty much how I think barristering works. Solicitors, most of the time they could probably park that ship themselves, but sometimes they just get somebody to come in and give them a hand because they've just got local knowledge. Like I say, we're specialist advocates. And there's also that thing, a good lawyer knows the law, a great lawyer knows the judge. I think that can have a legit meaning, which is we can know the foibles of particular judges, what they like to hear, how they like cases presented, what approaches work, what don't, how sort of, how to gauge their sort of feedback and reaction to know sort of whether you're on a winner or basically the judge has just lost interest. So, that's the sort of thing that's quite useful. So that's the traditional way of doing it. So what sort of changed in recent years? And, I'm using recent to mean sort of in the last 30 years. Well, the idea was that, the solicitor would sort of, gather the evidence, take statements, prepare the case, write sort of what we call a brief to counsel, which, depending on how good the solicitor is either a massive breakdown of the case with what all the facts are, what the issues are, what the instructions are, or quite often it's basically here's a carrier bag full of documents. Counsel is instructed to use best endeavours, and that was always quite a common one. But the idea is people say, well, hang on, I'm paying two lawyers here. Now, the argument is you're paying two different professionals to do two very different things. But you can see where people say, well, why can't I just explain to the barrister, what the case is about? Why do I need to tell you and then you charge me to write instructions to them? Why do you need to get the evidence? I've got the evidence. I know who the witnesses are. Why can't the barrister take the witness statement? Because barristers, we take witness statements quite a lot. It's something we are allowed to do. Although generally there is a little bit of a thing about trying not to take witness statements in relation to cases that you will then have conduct of, just in case somebody says, well, I never said that. my lawyer wrote that down, and then you get into all sorts of embarrassment. But yeah, that's the idea, that you should be allowed to, approach barristers directly if the solicitor aspect is unnecessary. So the first thing we got was what we called professional licensed access. And that was that certain bodies, and indeed individuals, could register with the Bar Standards Board, and they would be licensed to instruct counsel directly without a solicitor. Sometimes it's individuals, sometimes it's bodies and any members of that body. So say, for instance, Chartered Institute of Accountants, they have a registration. So chartered accountants can instruct barristers directly, but only in relation to sort of things pertaining to accounting. So like, we've got a client, we've done their books, they've got a row with revenue or something like that, or they're in the VAT tribunal, can you go along and represent? Something like that. They couldn't sort of say, "Oh, and actually, somebody ran me, the other day. Can you do a PI case for me?" Because that, the license is with the person, and it covers limited areas in their sort of area of expertise. Now, in that particular case, anybody with that license, and there's a big database actually. You can just go to the Bar Standards Board and download it. It's just an Excel spreadsheet to see, who is allowed and what they're allowed to do. They can instruct any barrister because it's the client that has the license, not the barrister. So they can instruct anybody. But we also have what we call direct public access. Now that is where it's the barrister who's licensed, and they can take any client. Of the approximately 24,000 currently practicing barristers, about 8,000 of us have the direct public access extension on our practice certificates, which allows us to do that. So what happens then? Well, basically, yeah, you can approach a barrister directly and say, I have a case and I'd like you to be involved somehow. But what's our level of involvement? Well, the thing now is we have a thing called unbundling, which is basically, instead of like, it used to be that you were instructed for the entirety of a case. So, from the earliest involvement to the end of it. But now you can sort of just instruct us for little discrete bits of the case. So you could come forward and say, look, I'm really happy to prepare all the paperwork myself, but I don't want to actually conduct the trial. Okay, so I'd like you to do the advocacy. Or they could say something like, look, I know this case reasonably well. I know it inside and out, and I'm happy to ask the questions and to say my bit in court, so I don't need you there. But I'm just not familiar with the procedure. Can you take me through? How do I prepare the witness statements? What's disclosure? Can you either advise me on that or do it for me? Okay, and like I say, you can pick and choose which bits you get us to do. Or just instruct us to do the whole thing. Now, one weird thing is, if you instruct under the direct public access scheme, even if you say, right, I want you to do absolutely everything, okay? As far as the court's concerned, the client is still a litigant in person. Okay, and that has some practical effects. For instance, all the court orders will go to the lay client. And this is actually an issue raised with the Bar Standards Board, although they said, actually, you need to sort this out with the court service, because you can't officially go on record when you're doing direct public access. And going on record means you let the court know, I am acting for this person, and it can be a solicitor. Solicitors usually go on record. And that just means send us all the paperwork, send us all the stuff about when the hearings are and what needs to be done, because we'll take care of that. Don't just don't send them to client, because they won't know what to do. So that's, one thing, that all the paperwork goes to the client. Now, it all depends. Some courts are happy to, even though I'm not officially on the record, to say, oh yeah, of course, we'll copy you into the orders and we'll copy you into the emails. And we'll speak to me on the telephone about the case. But other courts will say, no, sorry, you're not on record for this. We can't discuss this with you. You'll have to get the client to call. So that is an issue. There's also things like whose address you're going to write to, because it's like, a barrister might say, I don't want to be dealing with all the paperwork from the court or from the other side. That will have to go to your address, and we'll have to rely on you to sort of, bring it to me and ring me or let me know that the letter has come. Maybe scan it across to me so I can read it. There's all these sorts of things. Another complication is there's a thing called litigation, and like many words in the law, it has multiple meanings in different contexts. Litigation specifically means certain things done in the course of like litigation or court case, and that's things like filing witness statements, filing application notices, lots of the administrative stuff is technically what we call litigation. Now, the distinction between what is litigation and what isn't is really arbitrary. And it just seems to be based on what, before this, barrister solicitors and, litigation divide came in, because, like I say, solicitors are allowed to conduct litigation, barristers generally aren't. No, you need to be licensed to conduct litigation. You can conduct litigation on your own behalf as a litigant in person, and that's how this scheme works. But yeah, barristers aren't technically, we're not allowed to do litigation, except, and I'll come on to that in a moment. But just to sort of say, there is this really weird thing about what we can and can't do. And like I say, it just seems to have been based on what traditionally solicitors and barristers split between themselves. I mean, there's very little justification for some of the rules. Like, for instance, only licensed people can appear in court. Unless, of course, but barristers always used to send their clerks across to do directions hearings and things like that, just to get trial dates. And that apparently is not litigation, even because it's just, well, that's what we've always done. So yeah, there are certain things a lot of barristers, even if they've got the direct public access license, they can't do, like filing application notices and things like that. You'd have to say you have to do it. We can help you draft it, but we can't sign it and we can't drop it off at the court. However, some barristers, a very, very few, I think there's like 317 of us, are actually licensed to carry out litigation. So we can do all the, everything. We can almost do everything that solicitors can do. One exception is barristers cannot handle client funds. That actually has some quite interesting practical applications because the definition of handling client funds is quite large as far as the BSB are concerned. And that includes things like holding checks to pay court fees. So say, for instance, there is a court fee to pay. And I can actually file the application myself because I've got my litigation extension on my practice certificate. So I can do everything. And I go down to the court and I hand it in. They say, well, there's a £255 fee to pay here. Well, if I get a cheque from the client and hand it over, even that cheque is client funds, and people have got into trouble for doing this. So I say, well, that's all right. I'll basically, you just pay in advance, put in my account, and I'll just write the cheque or use my card myself. No, that's a really weird thing. We're not allowed to hold client money on account either. So this is a rather strange thing. Unless we do it as a fixed fee with everything included, in which case we can get the money up front, we can't actually have any money until we've actually done the thing. And I'll tell you the practical way I do it is I go down the court office, I write a cheque, I hand the cheque over, I then ring the client and say, okay, can you stick that in my account now? And as soon as it appears, I go, right, see you. And if it didn't appear within the requisite time, I would just ask for the cheque back. But yeah, it's a really weird thing that, and you've got to get that timing right. If you put the money in my account and then I transfer it out, I get into bother. It's got to be the other way around. It's rather a strange one. But yeah, so that's one element that does actually need to be considered. So how do you go around instructing a direct access barrister? How do you find us? Well, a lot of the time it might say on the Chamber's website. If you just go on the Chamber's website, a lot of the time it'll say, accepts does direct access work. There is actually also the Bar Council direct access portal, or at least it used to be. I don't know if it still exists. Where you can sort of go on and you put in where you live, what area of work you're looking for somebody to cover, etc., all that sort of thing, and it will match you with direct public access barristers. I mean, I used to get emails every now and again, sort of saying somebody wishes to instruct you. I'm not quite sure how good it is because on my list was, I do defamation and this sort of work, and people do, and people are going like, I'd like to instruct you in a family matter. So, and I think that's perhaps more the portal. But yeah, you can just. Like I say, just any other way of finding a barrister. And also if you go to the Bar Standards Board website, you can type in any barrister's name, and that tells you everything about us. How long we've been practicing, where we practice, any disciplinaries against us. But it also says whether we can do direct public access and stroke or litigation. So that's one way of finding out. So yeah. You just approach us. It'll be, the same way you'd approach a solicitor. Now, a couple of things. Cab rank rule doesn't apply. So we can actually pick and choose clients because the idea is there's no filter between us. And the other thing is we are under a duty to constantly assess from the moment we meet you and all through the trial whether we think actually we do need a solicitor in the mix. And it might be that I say, look, this case is too complicated. You're a very busy business person. You're not going to have time to do this work. I'm not going to do it. and you're not going to have time to draft witness statements and do disclosure, so you need to get a solicitor in. Or it may be we start off sort of going, yeah, that's fine, it's all working really well, but as we get through, the procedures, it gets a bit overwhelming for somebody, or there's more work than they expected. Or sometimes you just sort of like need, somebody in between you, just to sort of, I won't say translate, but sometimes, solicitors are there, they're used to dealing directly with clients. Whereas we're not, normally we refer to our solicitor as our professional client and our client as the lay client. There's always been that slight detachment there. Just a little fun aside. Traditionally, solicitors had to come through the tradesman's entrance, but barristers could come through the front door. I'm not saying whether I agree with that or not, because we were sort of gentle people and stuff, and we weren't, doing it for the sordid money. And I think I've mentioned that technically speaking, barristers don't get paid. We don't. We didn't used to have contracts. It was if you thought we'd done a good job, you would give us a little honorarium, as they call it, a little gratuity. And on the back of barristers' gowns, there is a little pocket called an honorarium where people would leave the money. The downside of that is we couldn't sue for fees. So if you didn't get the money up front and you just went away, it's like, well, no, there's no contract. Remember, they only pay you basically if they like you. That has changed now. When you will find that we do client care letters and contracts. But like I say, there is that issue that generally speaking, we can't hold your money on account. So we have to bill you after we've done the work. That can be in stages, by the way. So it's like, I went to court today, bill. I wrote a letter today, bill. Expect a lot of that. But like I say, all people will do it on fixed fees. So what are the pros and cons of this? Well, as I said, one pro is you can pick and choose which bit of the work you want us to do. It doesn't have to be all or nothing. So you can just come to us, you might want to say, do us a favour, just write us an advice on whether I should bring this case or not. Or could you draft one of the documents, either draft the particulars of claim or draft the defence, and I'll take over from there. So you've got that, that's the flexibility aspect. And like I say, that's called unbundling. So that's something you can ask and say, do you do unbundling? Some people say there's a cost advantage. I am not sure that there is actually. And we do say, actually, don't necessarily think, oh, I'll go direct access because it will be cheaper. Because remember, you're still going to be asking us to do the same work. We'd be asking the solicitors. And sometimes solicitors are just more efficient at it, or they can pass it on to a lower grade fee earner. So if that work has to be done, somebody has to be paid for it. And if you're asking me to do it, the person I want paying for it is me. Although you can obviously take a lot of the work on yourself. I suppose one area is you're not paying for things like instructions to counsel, or because you tell me directly rather than tell the solicitor and then they write and tell me, or things like that. So I suppose that there's possible savings there. But like I said, don't necessarily think that don't use sort of like the financial thing as the way to do direct public access. I mean, like I say, there are just some financial advantages, but I think a lot of it is you are involved with the case. You get to speak to us, and there are sometimes I like that with certain clients, and some clients will just say, "I'm instructing you directly. Here's all the stuff. I want you to do all the work." And sometimes that works, especially in that commercial sphere. I particularly like it because I do a lot of the animal rights defamation, so I get to chat to some really interesting, hardcore, dedicated people who put my little sort of try and remember to do change.org to shame and stuff, and I like it. And also, I just find we speak the same language. I mean, there are specialist solicitors out there who do animal rights stuff, advocates for animals, people like that. Actually, just them really. I'm sure there are other solicitors. In fact, I know there are. Sorry, Lee Day. But that's one thing. We can build that relationship. But the downside of that is sometimes people do need that filter between us. There's always that old thing that solicitors take your money, barristers make you cry. That was our respective roles. So sometimes you might just want somebody you can spend a lot of time with. Effectively being a therapist. Don't get me wrong. Sometimes that happens to me. A lot of the time, I've got clients. They'll ring up, they want to run through a problem, we'll chat for an hour or two, and then what they'll go, I'll say, yeah, happy to do it, and they'll go, hey, you know what, no, I'm fine. They just wanted to get it off their chest, and that's fine, that does happen sometimes. And also, like, most litigators will always advise you, if at all, never to litigate. And sometimes people just want to say something. And if somebody says something to me and it gets them off the chest and they are now happy and they don't need to get embroiled in litigation to achieve that level of satisfaction, well, that's money well spent on their part, I think. If they're not going to brood about it, they just wanted the advice as to whether they had a case or not. And sometimes just saying, actually, yeah, I think you've got a good case there. So it's like, thank you, I thought I did. But that's all they wanted, just the vindication. But sometimes you have to say to people, look, here's the up and down side of it. I mean, I get a lot of this. I don't do a lot of claimant-based defamation, or rather I do, but very little of it gets to trial, because I always say it's never worth it. Streisand effects. It's always going to backfire. It's really stressful. You're airing, you're washing in public, and today's headlines are tomorrow's fish and chip papers. So sometimes the best thing you can do is just keep your head down. So yeah, sometimes there is that thing. You've got that relationship with the barrister. But what other downside? Somebody's got to do all that paperwork. Some barristers will do it, but sometimes they no, okay, you go out there, you track down the witnesses, you sort out all the disclosure. I'll tell you what you need to do for disclosure, but you're the one rooting through all the documents and thousands of emails. So be prepared that you might have to do a lot of the work yourself. But sometimes people are good at that. They like it because it's like, hey, it's your case. Why not get involved in it? And sometimes you will have such an in-depth knowledge that no solicitor or barrister could get because you've been living with it. I mean, and again, sometimes that's a real advantage. Sometimes it's a disadvantage because sometimes you've conditioned yourself into a position where it's like, well, this is what I think this case is about. And sometimes like, well, yeah, you're very, you're too connected to it. But a lot of people can be really dispassionate about it and still do, great work and things. So there you go. Yeah, that's pretty much, like I say, that's one thing. You've either got the licensed professional access, so go on the BSB's spreadsheet and see if you or any organisation you work for on there, or yeah, like I say, instruct under the Bar Direct Public Access Scheme, and depending on what you want people to do, see also if people are licensed to conduct litigation, and just work out exactly how involved you want to be and what you want out of this. There you go, though. I hope you found that useful. If you did, please consider clicking the like button, sharing them, subscribing, and me and Lord Lubaduck, I'll see you next time.